That's what we need to do to get you to successfully complete this without going to prison for 20 years. 5 CR 519 is called the State of Texas versus, is it Joshua
Yes, sir.
Guidry? This, that was your motion that you filed. We changed this first name.
Oh,
It's not Justin, it's Joshua.
no, this is a different case. This is not.
It's not him?
It's not him.
Why isn't, let me see.
And the cause number maybe, but that's in over in court. That's some calendar.
Well, this is this cause number. You,
I misfiled it.
okay, what do you want to do with this?
Just ignore it. I'll have to refile it.
Here, Judge, I'll look it up and see if I can. All right, case.
I had the,
Yeah. Yeah, it's all filed in this case number. You got the first letter right.
different Justin.
It's easily fixable.
But there's only one case, right?
Yes.
With Justin. All right, in 25 CR 519, sir, you were charged with a first amended motion to revoke unadjudicated probation. And there are, what you pleaded true at one time to allegations 8 and 9, and we did not move forward with that. And there's not a note of why. But anyway, what are we going to do today?
He was, I believe, Mr. Laird filed an amendment motion to revoke alleged to new public intoxications. We were getting a pleas to those since.
I know, but I wrote true on those two earlier. We must have had a hearing on it and then, but we didn't move forward on it.
There's no updated pre-sentence report.
And I don't know what we did, Judge. I don't have my file with me because
What are we going to do then?
I guess if the probation office is ready to proceed, you determine.
They're always ready.
Continue or whatever the disposition is going to be.
Okay, ready to go then?
Ready, yes.
Or you, sir?
yes, sir.
All right, you've had a chance to think about this and talk to your attorney, right?
Yes, sir.
All right. In 25 CR 519, does the defendant, Joshua Guidry, waive a formal reading of this first amended motion to revoke unadjudicated probation? Can we proceed in summary?
He does, Renee.
And again, for the record, his attorney, Mr. Kimler, is present, and the state's attorney in probation office. In summary, this, and by the way, raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. In summary, this first amended motion to revoke unadjudicated.
All right, guys. What started as a routine probation hearing in a Texas courtroom quickly turned into a moment that could change one man's future forever. The case centered on Joshua, a defendant already walking a thin line after receiving deferred probation for a serious felony offense. At first, the courtroom was tangled in confusion as officials sorted out paperwork errors and even corrected the defendant's name on legal documents. But once those technical mistakes were cleared, the atmosphere shifted instantly. The judge turned his attention to allegations that Joshua had violated the very conditions keeping him out of prison. Every person in the courtroom knew what was at stake. One wrong answer, one careless admission, and the consequences could be devastating. What nobody expected was how quickly the hearing would spiral toward a dangerous crossroads.
Probation states that on August 7th, 2025, in this court, you were placed on 10 years deferred or unadjudicated probation for the second-degree felony of assault on it says peace officer / judge, but I think this was a peace officer.
It was a peace officer.
Public servant.
Is that true?
Yes, sir.
Okay. You talk to him about this. What does he intend to plead true to?
Well, I think he's already pled on.
Well, he's pleaded true. We're gonna have to redo it all. It's showing up.
He's already.
He sat out his time on the two public intoxications. So that's counts 1 and then count
8.
Yes.
I've got a true already on 8, but we can redo it. Is 1 necessary or can
We
we?
don't have to. I mean, the same thing.
Allegation 8, okay, states that you committed the offense of public intoxication. That's a Class C misdemeanor.
Scripture.
On or about October 31st, 2025 in Jefferson County, Texas, which was a violation of condition 1 of your deferred or unadjudicated probation order which states commit no offense against the laws of this state or any other state. Is that allegation true and correct?
Yes, sir.
And number 9 states
Gotcha.
you failed to never become intoxicated or be under the influence of any intoxicating substance, in that on or about October 31st, 2025, you were arrested for public intoxication, and that was a violation of condition 11, and which states do not become intoxicated or be under the influence of any intoxicating substance, including intoxication by prescription medication abuse. That allegation really is, it has to be, we have to tinker with this a little bit. Failing to never become intoxicated, you failed to never become intoxicated as you were arrested, which isn't a finding of truth or guilt. That's, you're arrested for probable cause, but public intoxication requires beyond a reasonable doubt. And you have admitted to committing the offense of public intoxication. So were you intoxicated or under the influence of an intoxicating substance on that day?
I wasn't intoxicated, but that's what they told me with.
Yeah. Well, you've just admitted, though, in number 8, that you committed the crime of public intoxicated. You just said that under oath to me. So did you just falsely tell me that you committed the crime of public intoxication, but you weren't intoxicated?
Yeah, so
Think about this.
better out in jail.
He said,
Think about it, because you told me under oath that you committed the crime of public intoxication, which meant you were intoxicated.
As prosecutors reviewed the probation violations, the focus landed on a public intoxication incident that allegedly occurred months earlier. The judge carefully read each allegation, making sure every detail was placed on the record. Then came the turning point. Under oath, Joshua admitted to committing public intoxication. But only moments later, he appeared to backtrack, claiming he wasn't actually intoxicated at all. The courtroom immediately froze. The judge didn't let the contradiction slide. Instead, he challenged the defendant directly, exposing the flaw in his statement. The tension became almost unbearable as Joshua was forced to confront his own testimony. Suddenly, what looks like a simple hearing became a battle over credibility, truth, and personal responsibility. Every answer now carried enormous weight.
Is that true?
Yes, sir.
That's what number 9 states. You failed to never become intoxicated by being under the influence of an intoxicating substance of some sort on or about October 31st, 2025, when you were arrested for public intoxication in violation of condition 11 of your probation order. Is all of that true?
Yes, sir.
Get ready for it.
Now, and I'm going to add a word so this is clear, because it says failed to never become intoxicated on or be under the on or about October 31st, 25, comma, he was arrested for public. And I'm going to add the word when. So when he was arrested for public intoxication, I think that works then.
no
That-
objection.
Right, the court has supplemented that allegation with the word when to make it more clear that you failed to never become intoxicated or be under the influence of any intoxicating substance in that on or about October 31st, 2025, when you were arrested for public intoxication in violation of condition 11 of your deferred adjudication order. And that is true and correct.
Yes, sir.
Are you pleading true and correct to allegations 8 and 9 of this first amended motion to revoke probation voluntarily and because those allegations are true?
Yes, sir.
Do you understand that a voluntary and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation can now be revoked and you can be sentenced to the full range of punishment, which is a second-degree felony in this case, carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Understanding all of that, do you insist on pleading true today?
Yes, sir.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. What are we going to do?
Judge, I don't want to put him in prison. I think he needs some
How
help.
much time
He's
is-
got alcohol problems and I don't know if he has a drug problem, but I know he's had some alcohol problems in the past. He's
Well, I don't
had,
think we can put him on regular probation for this crime.
we can't judge, but we can give him some either
ISS.
ISF or something along those lines. I'm not sure ready to send him to safety or not.
ISS services. True.
What do you want to do?
That sound good?
With probation? Well, there, so the probation office is the key.
Yes, sir.
Y'all close to it. What do you suggest, sir?
I believe safety would be a good recommendation, or ISF substance abuse with JCDI as aftercare.
Why don't we go condition the second thought?
Yes, sir. That's
All right, so
ISF substance abuse track.
intermediate sanctions facility
Yes, sir.
with substance abuse track.
Yes, sir. With Jefferson County Drug Intervention Program as aftercare.
Any objection?
no objection.
All right, here's what we're going to do, sir. Mr. Guidry, I'm going to find that there is sufficient evidence supporting this first amended motion to revoke unadjudicated probation are granted by preponderance of the evidence or greater, as allegations 8 and 9 have been proven true. And that is enough to grant this motion. Your probation can be revoked and you can be sentenced again to no less than 2 nor more than 20 years confinement in prison. But in lieu of that, what we're going to do is continue your probation.
Yes, sir.
You will be ordered to attend the intermediate sanctions facility substance abuse track, and that will be an amended condition of your probation. After that is completed, then you will work with the probation office here directly and complete the Jefferson County Drug Intervention Program aftercare program. The intermediate substance abuse felony ISF, that's inpatient.
Yes, sir.
And then that aftercare is going to be out patient. So
The pressure intensified as the judge meticulously broke down the legal language surrounding the probation violation. Every word mattered. Every phrase could influence the outcome. After clarifying the allegations, the court asked Joshua one final time whether he wished to plead true to the violations. He answered yes. That single word changed everything. The judge then delivered a sobering reminder that many viewers won't forget. Because of the probation violations, Joshua now faced the possibility of having his probation revoked entirely. The punishment range stretched as high as 20 years behind bars and thousands of dollars in fines. The reality of that threat hung heavily over the courtroom. Yet just when it seemed prison was inevitable, a surprising discussion began about rehabilitation instead of incarceration.
that's what we need to do to get you to successfully complete this without going to prison for 20 years. You understand?
Yes, sir.
All right, those conditions will be added to your probation and an order will be prepared, and then you will be transferred over to ISF and then come back and then work with the probation office. Taking care of your business, getting a job and things like that, taking care of your family. You have a family.
Yes, sir. Yeah.
Where are you in the great scheme of things? You've been putting yourself first, but you're not.
Okay.
Your family is certainly ahead of you. That's the way it should be. Get your priorities straight, take care of this, and be a role model for your family like you're supposed to be
Yes, sir.
by making the right choices so that you're setting a good example. You promise? Well, just don't talk about it, do it.
Okay.
Thank you. That is all.
Judge, do we want to leave this in therapy open and hold it in abeyance, or would it close it out?
You can close it out. I mean, if there's a problem, we'll just,
Reopen?
yeah.
Okay.